get the live stream up and running. Bear with me a second. Right, the live stream is on, so I'll just introduce the meeting. So what I would ask if the licensing subcommittee members could come onto the screen, please. I see obviously Councillor Norman's already joined, so thank you very much. Thanks, Councillor Hennessy. Thanks, Councillor Drake. Just thank you very much. Good morning all, and thank you for joining us this morning at the licensing subcommittee meeting on the Friday 2nd of May 2025. My name is Mark Thomas and I'm the Democratic and Scrutiny Services Officer who will be supporting the meeting today. Just before we start the meeting proper, I'm just going to go through some housekeeping and a short introduction. May I remind everyone present that this meeting is being live streamed as well as recorded via the internet, and therefore this recording will be archived for future viewing. If a participant wishes to speak this morning, can they please use the raised hand function button, which is at the bottom centre of your screen. And when invited to address by the chair, please could all participants ensure that their microphone and camera is on when they're actively participating. Please ensure that all debate is raised verbally and not via the chat function for the sake of the recording. Could I also say good morning and welcome to all the interested parties that are also in attendance this morning. In terms of other introductions, I have my colleague Charlotte Weston, who is also providing technical support with me today from Democratic Services. We also have Mr. Richard Price, who is the legal officer of the council, and Mr. Will Lane, who will be the presenting licensing officer for the council. As you can see, hopefully licensing subcommittee members are on your screen currently, and I'm sure they will introduce themselves shortly. But first order of business this morning is to ask the subcommittee for nominations for a chair for this meeting.
I'd like to nominate Councillor Drake, please.
Okay, thank you very much, Councillor Hennessy. Councillor Norman, are you in agreement with that as well?
Yes, second that.
Right, okay. As there are no other nominations, Councillor Drake is duly elected as chair of the committee this morning, so congratulations, Chair. I will hand over to the chair now for the rest of the agenda. Thank you, Chair.
Right, thank you, everybody. We now need to receive any declarations of interest and the nature of such interest under the Council's Codes of Conduct. Do we have any declarations? No? Right. I'll move on to item number 4, which on my list, which is the report from the Licensing Authority, Licensing Act 2003, grant of premises license Domino's, 15 to 17 Houghton Road. And I believe Will Lane will take us through this report.
Yes, thank you, Chair. So this report concerns an application for a new premises licence for Domino's at Houghton Road in Barry. As background, in 1.1 of the report, the authority received an application from Digital Limited for the grant of a new premises licence. And for members' purposes, the application is at Appendix A of your bundle. Members will note that the application requests provision of late night refreshment Monday to Sunday between the hours of 11 p.m. to 5 a.m. There are additional conditions which have been proposed by the applicant, and they're at Section M of the Appendix A, the application. I won't run through them all, but they do include a condition that the premises will close to the public at 2 a.m. and thereafter operate only as a delivery service. So the premises currently trade under an existing licence, detailed as per 1.5 of your report, where the provision of late night refreshment occurs between 11 p.m. and midnight, Thursday to Saturday. And the current licence is reproduced in the report at Appendix B. So during the consultation period, 2 representations were received from other persons, from Barry Town Council and local member, Councillor Johnson, who I understand is here today. Now, the representations are detailed at Appendix C. Additional representations were also received from South Wales Police. However, South Wales Police have subsequently agreed conditions with the applicant. Now, the agreed conditions are at Appendix E of your report, and it is proposed that these conditions are imposed on the licence if members are minded to grant the application. Finally, a representation was also submitted by the Council Pollution Control Team, and that is at Appendix D of your pack. But since the report was published, however, the applicant and Pollution Control have agreed conditions, and this has been included and circulated in the supplemental information which committee has received. And what is proposed is, as with the police, if members are minded to grant the application, that those agreed conditions with Pollution Control are also imposed on the licence. So finally, I would point members to the recommendations in point 1 as to the determination of the application in accordance with the Council's Statement of Licensing Policy and the statutory guidance issued under the Licensing Act 2003. So that's a very quick run through the report. Happy to take any questions if there are any.
Does any member wish to raise any questions with Will Lane?
Sorry, just the one. Well, the notification from Barry Town Council still stands, does it?
Yes. Neither of the representations from the Town Council or Councillor Johnson have been removed, so they still stand.
Thank you.
No further questions for Will? No, I can't see any other hands raised. Right, I will move on and invite the applicant or their representative to present their case. I don't know who's going to do that.
Good morning, councillors. It's related from Licensing Law Consultancy. I'm here today to represent the applicant. I do have a representative from the company today, but it will be myself that will be presenting the case on behalf of the applicant. So with your permission, councillors, I propose to start at this moment.
Yes, that'd be fine.
Okay. Thank you.
Oh,
I was just in a nutshell what essentially our case is. Sorry, can you still hear me?
Yeah, it's freezing slightly.
Oh, right. Okay, I apologize. Are we okay to continue now?
Yes.
Chair. Okay. Yes, as I was saying, at the outset, I would like to summarize what our case is before going into the detail. And it's this, that our case is that the application should be granted as applied for, subject only to the conditions volunteered in the operating schedule and also the conditions agreed with both the police and the mental health. I'll say that because there is no logical or evidential basis for refusing the application. As you will know, councillors, that we can only do what is right in law for today's purposes and only take into account what is relevant and real and substantiated evidence. And when I say right in law, I do, of course, mean the Licensing Act, the statutory guidance, the licensing policy, the council's policy, and, of course, case law, but only where they are all consistent. Now, the issues in this case are fairly straightforward, but I think it'll be helpful for everybody for me to set out the background to the application and put it all into perspective. The starting point to note for alcohol or regulated entertainment. This is an application for late night refreshment, which is by far considered the safest of the licensable activities. This applicant is a multi-site Domino's franchisee with around 40 stores in England and Wales, and they employ around 1,400 employees, including area managers and office-based staff who deal with things like HR, admin, property, licensing, etc. So it is an organised and professional organisation who know this industry well and have been operated in this space for many, many years. It's also important to note that they have several sites which have similar premises in similar locations, and they operate very successfully and without any unnecessary onerous conditions. And many of those sites do operate late into the early hours of the morning, and many of those sites are based here in South Wales. The operators, the applicants, have internal procedures whereby they close the front of the store when it's not operated for deliveries, and they turn off signage, lighting, etc., which is designed to stop people congregating after a certain time in the evening. And the drivers are trained and instructed to work in a respectful and quiet manner. So they have a proven track record in this industry in England and Wales with a good working relationship with the responsible authorities. And that brings me on to the responsible authorities who did initially make a representation in relation to this application. And the first one was the police. Now, as part of this application process, we liaised with the police, and that was in the spirit of working in partnership with them, and reached an agreement with them to alleviate their concerns. And you will have seen details of that in the hearing papers, and which was also helpfully outlined when the report was being summarised this morning. You will have also seen that the police were generally supportive of the application and did not have any issues with the hours applied for. They were also generally happy with the conditions which were volunteered by the applicant in the application. And all they wanted was simply for the wording to be modified and to add one extra condition which the applicant agreed to. Now, why is this important? Well, as you will be aware, the police are recognised as the main source of advice and expertise on matters concerning crime and disorder. And they are, of course, as I say, in support of the application. And more importantly, they are satisfied that the licensing objectives will not be undermined as a result of this application if it were to be granted. We also liaised with the environmental health officer in relation to his representation, and also reached an agreement to alleviate their concerns. And that should be given significant weight because, as you'll also be aware, the Environmental Health Department is the statutory body and the main source of advice on matters concerning public nuisance, which is essentially what we are looking at today in terms of the two remaining representations, which have not yet been resolved. Therefore, the main authorities and experts have considered this application and have decided that they have no issues with this application being granted, subject, of course, to the conditions which have been agreed. And this is not surprising, as it was confirmed to us during our consultation with the environmental health officer that there have been no recorded complaints against these premises. And that then brings me on to Councillor Johnson's representation. Having reached an agreement with the responsible authorities on the conditions, we then reached out to Councillor Johnson in the time available. And again, we did this, of course, in the interest of working in partnership and hopefully to find a way of resolving this matter based on conditions agreed with the responsible authorities and perhaps any other conditions which may have transpired from any mediation. However, Councillor Johnson felt that he should allow this representation to be heard at a public hearing, which is fair enough. But the difficulty for him today is that there is no evidence whatsoever to support the representation, the main part of which you will have seen from the bundle is a short, generic and speculation-based representation. And that's it. There's no evidence of any complaints. There's no evidence of any premises-specific issues. There's no appreciation of the balance that will be created by the conditions volunteered and agreed with the responsible authorities. And I emphasize here that the responsible authorities have carefully considered this application and come to an agreement on conditions to help alleviate their concerns and also be in a position where they now have the occasion. And there's also no evidence of any local emotion in relation to this particular application, certainly not on the evidence that's before you today, and allegation. And that is simply not enough, councillors, I'm sure you will agree, to influence a licensing decision, because to do so would be grossly unjustified, inappropriate, and of course disproportionate. We appreciate the licensing objectives are phrased using the word prevention of public nuisance, prevention of crime and disorder, and so on and so forth. But the reality is we still need some real and substantiated evidence. Otherwise, it will be impossible for the grant of any application to promote the licensing objectives. Now, you will know also from the case commonly referred to as the Thwaites case, that where representations, as in this case, challenge the view of the responsible authorities, then not only do they need some evidence, they actually need an extra layer of real evidence to support their view and their case. And here they are have difficulties on both fronts because there is no evidence whatsoever. With regard to the second of the two representations, which is also alluded to in the first representation, and that's in relation to planning. There's nothing really there of any substance. It's just a cut and paste job from a planning decision, it seems, without any narrative to say what their case actually is. But just to address you further on that, case law and guidance, and I'm sure your legal advisor will confirm this with you, confirms that planning policies and considerations should be kept separate from licensing. They are two separate regimes, although they happen to be administered by the same council. And the guidance makes it clear that planning and licensing decisions in respect of the same premises can legitimately differ because their respective decision makers have to apply criteria which are different. I don't propose to go into any more detail in that in terms of what the guidance and the case law says, because I think that is fairly settled, unless, of course, your legal advisor would like me to go into a bit more detail after I've concluded the opening in our case. So it's also important to note that the planning department has not made any representations against this application because presumably they take the view that it's not relevant for today's purposes, and should they be a planning application, at a later date, and that's when they can get involved legitimately. As I say, like the other representations, this should also be given significant weight because the planning department are, of course, the main experts and the source of advice in matters concerning planning. So for all those reasons, and particularly because there's no evidential basis for refusing this application, it is our case that the application should be granted as applied for and only subject to the conditions which have been volunteered in the operating schedule, and also the conditions which have been carefully discussed and agreed authorities in relation to crime and disorder and also public nuisance. Councillors, unless I can assist you further, that is our opening and in our presentation of our case, and we're happy to take any questions if you so wish to. Thank you.
Councillor Norman, do you wish to say anything?
No, Chair, I've just come back online.
Oh, no, I unfortunately, I switched myself off. Right, right, we can move. Oh, Councillor Hennessy, did you want to raise anything?
You're muted,
You're on mute.
Councillor Hennessy. You're muted.
We can't hear you.
Sorry, I hit the wrong button on my computer. I just have one question, if you don't mind answering me. Are there any other Donamo pizzas opened until 5 o'clock?
Sorry, is that a question to
Yeah,
myself?
sorry.
Yes. Oh, yes. Sorry. Yeah. I mean, just by way of background, in terms of Domino's, I have about 3 or 4 clients which, between them, operate in excess of about 300 sites. This particular applicant operates around 40. It may be more.
Oh, you've frozen.
I've lost him on my side.
Yeah.
More
I
than
don't know
them. They operate successfully. Sometimes we do get. Am I back? Am I back?
Yeah, that's right.
Yeah.
Quality, yeah.
Am I back?
Yes.
Am I back?
Yes, you are back.
Okay. Yes, sorry. I was just saying that. Yes, I mean, we deal with premises around 300 for a handful of our clients in the Domino, with the Domino's brand. This particular one, they have about 40, and many of those do go late into the early hours in the morning, and many of them do have 5 a.m. and operating successfully without issue. We do sometimes, when we apply for these late license, get the some objections similar to today. But what seems to happen is once it's granted, we put our procedures in place, and there's never any complaints moving forward that we've been made aware of. So I hope that answers your question, Councillor. But the point is, yes, they do have 5 a.m. and they do have experience of operating those very successfully.
Okay, can I ask another question, please, Chair?
Yes, you can.
Right, you have where your Donamos is, it's literally right across the road from where I'm sitting at the moment. There's a lot of residential properties around there. There's a couple above your shop where the shop is currently. What are you going to do to mitigate the noise from the vehicles? Because I know it says in the paperwork that your clients' drivers will turn their car engines off and all that lot. But you can't guarantee that they would do that. So what is your client going to do to stop the noise and the constant, because one street where all the drivers park is a residential street with a lot of children on it and everything. So I'm particularly interested what your client is going to do to combat
Chair,
the noise and everything.
Yeah, I hear where you're coming from, but the way the licensing regime works, it's a permissive regime, and case law tells us that the way it works is to grant the application. If there are any issues, we'll deal with those as and when they arrive. You can't speculate about what may or may not happen without any evidence. And this is a classic case. There is not even a single allegation. Having said that, it's not a complete suck it and see regime. And that's why we have these procedures whereby you can make representations, and the responsible authorities who are local to the area have considered all those factors, considered how licensing works, and with that in mind, we have agreed the conditions going forward. You've got to allow the conditions to become part of the authorization. And in most cases, there is never an issue. But if there is, then that can be resolved with other powers under the Act. You can't speculate about what happens to address it for today's purposes. Now, also, nuisance is a two-stage process. First, you have to establish that there is actually a nuisance, that there will be a problem, and then you can address that. We can do some of those things preemptively, which we have done by the experts that are your eyes and ears, if you like, within that area, i.e. the police and the environmental health department. So those are the best assurances that we can give you at this stage. What we can't be doing is speculating about something that may or may not happen moving forward.
Okay, thank you.
Right. Nobody else wants to raise anything? No? Okay. Well, I'll move on to the next bit, which is responsible authorities. Do we have anybody present today?
Don't believe so, Chair, because I think all the relevant responsible authorities have had their issues addressed, as Mr. Rathore and obviously Mr. Lane have already alluded to. So unless Mr. Lane can say we got any, I don't think we've got any on today.
No, Mark, I can confirm that none of the responsible authorities are here today.
That's fine. Right, we'll move on now, and I'll invite Councillor Johnson to speak as one of the interested parties and outline their case about this issue.
Thank you very much, Councillor Drake, and thank you much to Mr. Rathore for his presentation earlier. I think it's worth saying. So I suspect that that Mr. Rathore seems to be perhaps doubting my the reasons behind my my objection, or expressing concerns about my my level of experience. Obviously, I'm a local ward member for the area where Domino's is for 13 years, and also a local resident. In fact, I'm such a local resident that I'm a regular user of the Domino's store, and in fact, this is more of an in practice than an in principle objection. And I'm using the phrase objection because in reality, it's around concerns, and it's around the implementation of the later license that's being proposed here. It's not the intent here is not to prevent Domino's from operating. It is to ensure that the mitigations that are put in place, which have no negative impact upon the local residents in the area. Some of those you will have heard have already been agreed with the environmental officer who had initially put in a similar request for objection as myself, and those have been included within the pack. Mr. Rathore, I'm very grateful to him for reaching out to me earlier this week to ask if I was of a similar mind to withdraw, and I've explained to him and to other councillors, I think were included in the email, that I felt that at the point where we had been we had published the papers and arranged the meeting, it made sense for us to continue with the process in order that these can be heard in a transparent manner, and that I can explain and have evidential record for local residents when they have queries about this application. If they have any concerns, then we can say that these were raised in a proper manner here with the applicant. I'm well aware that there are a number of Domino sites which operate until well into the evening. This is a commercial decision, and they are well within their rights to do that. I have no particular problem either with the 2 o'clock application for 2 o'clock in-person attendance on site. Halton Road is generally a quiet area at that time of night, although it is the town centre. The reality of the situation, as we know, is that the pubs in the area will have closed by around about midnight, and we know that most of the takeaways also will have stopped serving to individuals at that time. So it is hence the feelings supported by the police, for example, that this is not likely to cause additional antisocial behaviour in the area. The main concern held by myself as local council, local residents, and I believe also by Barry Town Council, is simply in relation to amounts of noise were generated as a result. These include that, as Councillor Hennessy has intimated, that the car park is to the rear of the building, and we wish to be assured that mitigations are in place to minimise the amount of noise from the coming and going of delivery drivers in that area, whether that's slamming doors, whether that's engines idling, and whether that's sort of conversations taking place outside in a space where people are going to have conversation taking place from 7 o'clock in the morning or so until clearly late at night. I believe, to some respect, the mitigations agreed with the environmental health officer do meet those. I would like, and I appreciate that I don't know if Will Lane is able to answer the query, because there is in the supplemental information that we have. It says, it has been agreed where possible that management instruct delivery drivers to park the vehicles at the front of the business to prevent noise issues from vehicles starting or idling from causing an issue to nearest residential properties. And I'm looking for clarification on that, because that's slightly different to the proposed mitigations in Mr. Rathor's email to the officer. Which is about guidance and guidance to switch off engine, etc. There is I don't know if Mr. Rathor knows the property of the area in detail. Fundamentally, the front of the shop opens onto the main road, and the main road would be relatively quiet at this time of night, whereas the ordinary delivery driver car park faces the rear and faces therefore onto a residential street. There are also flats which are above the property. So really we are looking to future-proof concerns that people have with regards to noise emanation from delivery drivers later into the evening than the current midnight, I believe it is, or 1 o'clock that's currently being utilised by the store. The second issue is inevitably a lesser issue, but the route that the deliverers take is through a residential street, similar to the initial concern from environmental health about noise carrying. That's used as pardon the phrase, a rat run from because it's easier than going through the one-way system in town. But we are concerned that will lead to an increase in noise from vehicular traffic through the night, which would not be ordinarily not normally be accepted within a residential area like that. Those are the two issues that concern me, and being able to show, as we are today, that those concerns have been raised with the applicants, the mitigations have been put in place. Is my main concern at this point in time, and also just for me to be able to understand, I would helpful if Mr. Lane could come out just to explain the process, on camera, of if people do have concerns or complaints, and Mr. Rathor talked about the two-step process for a nuisance concern. If people do have concerns and complaints, how those can be articulated and explained so that the franchise owner and managers can further mitigate should any of those problems occur in future. So I think that's the number of my points. I don't know if there's anything there Mr. Rathore would like me to unpack further, but those are the two main points, which is around the impact of the delivery drivers coming and going, and the different location, because that's within the supplemental information, a request to do the front of the building rather than the rear of the building for delivery drivers late in the night, and also sort of that further issue around use of route run, and sort of how we can ensure that there aren't any complaints that are met, are received, can be constructively dealt with. I'll stop there, Councillor Drake.
I don't know, Chair, whether you want me to come in at this point. Or,
Yeah.
I mean, there have been discussions with the applicant and the Environmental Health Officer, which, as the I'm representing the licensing authority here, haven't been party to. So I would have to go by the agreed conditions, which in the supplemental information are points 3 and 4. However, within that, there is an element of minimising other noise caused by their activities and switching off engines. As to the where the delivery drivers will be, I mean, it may be that Mr. Rathore can enlighten committee as to what was agreed with the Environmental Health Officer. However, as to your wider point around the should issues arise, what recourse would residents have about complaints that they had, then obviously we've got the Licensing Act, which has the capability to deal with any issues that arise with the premises. Initially, as with all enforcement, it's a stepped approach to enforcement where you'd engage with the business, look at what the issues were, try and identify if there were any changes to practices that could be made to rectify those issues. So that would be the normal method by which these things are resolved. Obviously, we also have the Licensing Act itself has powers where, if no agreement can be reached and there's really a serious problem, then there is always the option of a review being called for, where the whole of the licence can be looked at, and the committee can consider any issues that have arisen as a result of the business operating. And finally, we have statutory nuisance powers under the Environmental Protection Act, which are separate to the Licensing Act, but can also be pertinent on some occasions. So I think the message to residents would be, if the committee were minded to grant this application and there were issues, the first point of contact would be to contact the SRS. We've got dedicated contact numbers or emails that people can contact us on. We would engage with the residents, find out what the issues were, and then we'd discuss with the business. So I don't know if you've got any questions on that, or whether that answers your query.
That's fine, Mr. Lynn, thank you.
Thanks.
Yeah, I just got one question. These delivery vans, what size are we talking about?
Cars,
They're cars, are they? Not vans.
I don't want to cut across Mr. Rathore, but I'm under the assumption that pizza delivery drivers operating between, say, midnight and 5 in the morning are going to be the same people driving cars as they were between 7 o'clock and midnight and 4 o'clock and 7 o'clock. I mean, I think there's potentially we're confusing ourselves here, Councillor Drake, between delivery vans, delivering a wider, 40-ton Arctic lorry bringing all the goods in, and these are people delivering pizzas to people's houses, which they've ordered through the app.
So it'd be one of these cars where they put a sign up above, is it? I presume so.
Yes. It's the concern. Sorry, Pam. Concentrate. Just to clarify, the concern that I'm raising is obviously that takeaway premises, within the town centre, within High Street, etc. Rely on a number of people who will be coming and collecting. They'll be driving in their car. They'll be hopefully turning their engine off, going in to collect the delivery they're going to have, going back out to their car. And there is the concern raised is, leaving the car running while they go in and collect, speaking to others, sort of chatting whilst waiting for foods to be completed, packed up, ready for them to deliver, and then slamming doors either on their car or when the back door to the premises is open, because usually that's left open. Or often that's left open when I walk past, so you can see noise coming in and out. And the question that's raised within the environmental health officers' points, which are not entirely included within the agreed points there between Mr. Rathore and the officer. The email, which includes supplemental information, makes a suggestion of utilising the front of the building, which opens onto the main road, rather than the allocated car parking space for Domino delivery drivers, which is to the rear of the building and is on Beryl Road, as you're probably aware, Councillor Drake, next to the by the church. Yes. So hopefully
I was going to raise that.
That's a beautiful place there, Mr. Rathore.
I was going to raise that because they didn't actually quantify that, did they? And if they parked out the front, they wouldn't have to go up the side streets, which are one-way streets, would they?
May I assist with that, Chair? First of all, thank you very much, Councillor Johnson, for your for amplifying your representation today. I think you've been very fair and probably one of the most respectful in terms of councillors making representations. I deal with all sorts. So first of all, thank you for keeping this as civil as you have done. Secondly, we did speak at length with the environmental health officer regarding the parking at the front as an alternative. We don't have an issue with that. That's the starting point. But I just want to go one step back and say that, and hopefully this will answer another one of your questions as well. This applicant's not been in this industry for decades with that many premises, without issues after the application's been granted. We do get concerns before they're granted, but after, without having a good relationship with the residents. And I think the officer a few moments ago beautifully explained the procedures that are available to residents, and I couldn't put it better myself. But there is another layer of that. If there are concerns, and particularly yourself, Councillor, with you being in the area, walk into the premises and say, guys, I've got a complaint here. We're not happy about X, Y, and Z. That's an informal thing, but it may help you come to a resolution without having to take formal action, which can be time-consuming, etc. So I hope that gives you some sort of. It's not something we can particularly or we want to condition on the evidence, because there is no evidence of any problems. But the offer is there. Walk-ins, ask to speak to the store manager, say we're not happy about this, and then we can work towards working in partnership with you, because we all need to get on as neighbours here. Going back to the parking at the front, the answer to that is yes, we will use whatever it takes to alleviate the concerns of any residents. So moving forward, we can look at that front space if it works better. The reason why we didn't condition it, and I'm sure your legal advisor will support me on this, is because it's part of the highway and you can't really condition something that's not within your control. But if the spaces are there and it's going to work better, then this is, I guess, an informal assurance that we will look to utilise that, but without it being, a condition which can't be imposed.
Yeah, if I may, Councillor Drake, I recognise that, and I'm happy with the idea that the store manager will operate in as conciliatory fashion. That's not the right phrase in English, but will take into consideration the impact upon local residents and what operates in the best interests of the business. I will say, however, Mr. Murthaw, that I appreciate the concept of informal discussions. I think that there is also a place for, if complaints are received, then they should be dealt with in the proper manner on the basis of you did ask earlier as part of your presentation at the start of this meeting, you explained that there had been no complaints or no formal complaints. And I feel it is important that if complaints are made, then they should be on the book and dealt with properly, because otherwise, if I come to meetings like this, then you would, next time round, you may also say there are no complaints, and I say, well, I've been to speak to the store manager. Well, why isn't that written down? So I appreciate your point fully about sort of looking to resolve these things in an informal manner. However, should issues arise, then I would also ask people to report them in the proper way, so that the proper authorities have a record of those. Even if the resolutions for that may be as easily done in an informal fashion. It's a chicken and egg situation, isn't it?
That's not something I'm going to, it's not something I'm going to disagree with. We were just offering something over and above. So that will be down to whoever wants to complain, whether they want to go straight to the council, the store manager, or both. What we're saying is we're not saying this is an alternative. This is an extra layer that we are offering.
Hopefully, Mr. Athor, there won't be any complaints, but sort of we're future proofing it. Then that's my issue. Thank you.
Right then, I was going to ask Councillor Johnson whether he wanted to sum up, but I think he's probably raised everything.
I think again, I think Councillor Drake, we've reached a point here where the issues have been raised with the applicant's representative here, and I believe I'm not sure. Sorry, I think you said that you have a colleague here on the call. So they are predominantly, as we say, around noise, incidental noise as a result of late night delivery from the premises. The concern, and it's a lighter concern, but as I say, there is a side street, Lombard Street in particular, which is used by drivers at the site in order to navigate the one-way system through town in a quicker manner. And I am. It can't be conditioned naturally, but it is. I am making the request that there is a conversation with drivers about using wrap runs where other main roads are available, and so as not to disturb local residents.
Oh, thank you very much for that. I'm going to ask now whether the applicant's representative wants to sum up on things.
Yes, please, if I may, Chair. I just want to make a couple of points here before I go into my summing up. The phrase future-proof has been used a couple of times today. That's not how licensing works. And this is not, I'll stand by what I said about Councillor Johnson, probably the most respectful manner in which anybody has put forward a representation and very understanding in his position. But this is also not a forum for protecting their interest, if you like, in terms of how they might look to their constituents, that being a regime at all. And and again, before I go into my submissions, there is a paragraph in your policy which says that the licensing authority will be alert to any attempt to impose conditions where there is no evidence of problems at the premises, and that's lifted straight from your statement of licensing policy. So this application, despite there being one already in existence, and the applicant is entitled, of course, to have it determined on its own merits, and it is well known that the licensing regime, as I've already said, is designed to be permissive unless the evidence suggests otherwise. That's part of your main test today. We have never received any direct complaints, and there is no such evidence presented by any of the parties whatsoever. So the representations are flawed for the reasons which I've already mentioned, or they go into matters which are not relevant to licensing, such as highways issues. On the other hand, we have an applicant who has a proven track record in this industry with around 40 premises all over England and Wales, and as I proven track record of successfully implementing management plans and working with the responsible authorities. The policy states, your policy states that it recognises, the council recognises the important role that licensed premises play in communities by minimising regulatory burden on premises and supporting responsible premises. And I would say this is one such premises and an applicant who is responsible. So just coming towards the end now, what I would do is like to emphasise to help you with your decision-making process today. Number one, that the responsible authorities support this application subject to the agreed conditions. The design of the application was intentionally geared towards staggering closing times to avoid any unnecessary congestion in the area. In fact, the bespoke condition which restricts or allowing deliveries only was designed to reduce foot traffic during the later hours, but while still supporting and maintaining a strong nighttime economy. And there has, as I've already said, been no evidential basis within the representations to suggest that this position will ever change. Agreed conditions are insufficient to promote the licensing objectives. Therefore, there is a justifiable case here which will stand up to scrutiny to safely grant the application subject to the conditions agreed. And of course, as your officers have very helpfully set out, if there are any problems, then there are provisions to review the premises license should there ever be any problems, and as well as powers under the environmental protection legislation. And with that in mind, the only logical conclusion is to grant the application, because that would be then consistent with the legislation, the statutory guidance, your policy, and of course, a case law. You are, of course, required to give clear and full reasons for your decision today, a decision which must be robust and can stand up to scrutiny. Chair, I would say that if you follow the process as we have set out today, you will be making a decision that will be robust and can stand up to scrutiny. Unless I can assist you further, Chair, that is our case for today.
Thank you very much for that. Can I ask the committee members if they wish to seek any further clarifications or on any of the points raised? No, I can't see any hands raised by our other two committee members. Right then, I thank you for your attendance today. I don't know whether Richard wants to come in and advise you of the process that will happen afterwards. Richard.
Yes, good morning, Chair. To the applicant, we'll obviously consider the matter in camera, and the decision will then be relayed to you. That decision will be provided in writing within the next 7 days. In all likelihood, it'll be a shorter period than 7 days, and it may be possible that it'll be communicated to you today by the licensing officer, but that depends on how we progress from here on in. Do you have any questions in relation to the process?
We got to remember we got bank holiday Monday.
Yes.
Okay, everybody happy with that? Right, as a committee now, we will retire and go through all the relevant information. Thank everybody.
Right. Just to add, obviously the committee will go into a private session now. So I would ask that obviously the representatives from Domino's, licensing officer and Councillor Johnson now leave the meeting and then we'll go into private session. Thank you very much.
Thank you very much.
Everybody gone?
Yeah, bear with us, Chair. We'll just go into